condo and okay, thank you. The HOA and property docs. What is the difference between a property owners association versus an HOA situation? Are they this one and the same? Because I've been told by several agents that it has on their listing, they'll be like, it's under a property owners association. I'm like, so I need the docs. No, there's no HOA. And I'm like, that's the, and then it turns out to be like, this one in particular turned out to be like there's this informal property owners association that they don't have to be associated with if they don't want to be. And I'm like, then why are you putting in the listing? Like,
yeah.
What say you?
Right. So the Property Owners Association Act is the whole thing that covers all the HOAs. And there are some HOAs, homeowners associations, it's basically interchangeable. Okay, so we'll start there. HOAs and property owners associations, POAs, they're the same. There are some associations, excuse me, that are optional. They're small associations where the owners can opt in and pay for certain additional services, right? That's very rare that happens. Most of the time it is not optional and they have to be part of it. And so there wouldn't be disclosure packets that are delivered. There's not architectural guidelines. There's not rules that have to be adhered to, and there aren't monthly or annual fees. For the most part, when you run into an HOA, it's not optional. And so that's why these disclosures are required to be delivered by the seller, because the buyer has to know what they're getting into. They have to have the option to see what the required rules are, what the architectural guidelines are, what they're allowed to do or not allowed to do. You can have a buyer who's like, oh, I want a pool in my backyard, right? And they go and they find this lot and it's level and it's big, and they're like, oh, this is wonderful. This is perfect for my pool. And then the HOA rules say no private pools, right? So they have to be able to review those things in order to move forward. Same thing with home-based businesses. There's a lot of buyers that run home-based businesses and there are HOAs that don't allow them. And so they have to be able to review those rules. But HOAs are governed by the Property Owners Association Act. So they are essentially one and the same. Did that help answer the question?
Yes, it did. Thank you.
You are welcome. Yes, Mary.
What is my rule in reviewing the HOA packet? Which documents in specific I have to read with my clients and tell them about?
Okay, so Mary's question is, what is our role as an agent in reviewing these documents? So our role is that we are not required to read any of these documents as a buyer's agent. It's not our responsibility to read the documents, because it's not up to us whether the agent or whether the client likes it or not. Now, what I will tell you is that they've hired us for a reason, and they want us to guide them through their transaction. So if we know that they are buying a property because they want to put a pool in the backyard, it is a really good idea for us to review those documents also to see whether or not it says they can have a pool. It is not on us to make that determination and then tell them whether or not they can have a pool. They need to review the documents to make that determination. But we should be reviewing it also and say, hey, check out page 322 where it talks about pools, right? Because this might not work for you, or this says that you can have a pool, read it, maybe call and double check. Client, right? Tell your client to call and just verify with the HOA. We should always be reviewing the 6-page disclosure statement that comes on the top. It's the cover page, right? It's the one that looks official from Deport that talks about what the monthly fees are, whether or not they can, like what the rules are for flagpoles and signs and like all of those things. That's also where they list the violations so that we can help to communicate with the listing side if we're the buyer's agent on getting the cure letter. And if we're the listing agent, then we're communicating with our seller to make sure that they have everything done and that we get the cure letter delivered to the buyer before closing. Okay, HOA violations are non-negotiable. So the seller must deliver a cure letter or the buyer can walk away. So it doesn't matter whether these were things that were discovered in the home inspection. It doesn't matter whether these are things that the buyer could see when they came and walked through the property. These are part of the HOA, which is a lien, essentially on the property, and they're not negotiable.
Shannon,
yes.
You mentioned the other day that on the contingency addendum, the as-is section, that you could write an offer about HOA violations.
Yes, we'll go over that next week. I'll show where that can be removed up front. That's generally with a tear down or a short sale or something where the seller is not able to make any repairs, and that's up front that everybody is agreeing to that. But after the fact, it's not negotiable.
Okay.
Yes, Misty. Yeah.
Just in your experience, how often would you say back out because of HOA documents or something? Very often?
So the question is, how often do buyers back out on HOA docs? So I would say it depends on the market we're in. Right now, I would say that we're probably a little higher than normal where people back out on HOA docs, and it's not because of the HOA docs. So in general, it's maybe 5%, right, of all transactions, people back out because of HOA docs. And now I'd say maybe 10%, 15%, like there are a lot of buyers that have buyer's remorse now, and they use the HOA docs to get out.
So do they not have to disclose why?
Correct.
Something's in there?
That's correct. So buyers can walk away up until 3 days after receipt of those documents, right? So they don't have to wait till they get them to walk away. So let's say they have a home inspection contingency. They do this right to void only, and they do the home inspection, and they're like, oh, there's all these things that have to be repaired, and the seller isn't going to do anything. I'm just going to walk away on HOA docs. Or they use the HOA docs as a negotiating tool to say, hey, seller, do all these things, or I'm going to walk away.
So it depends on the timing.
It depends on the timing, and that's why it's super important to have those documents as soon as you ratify and you deliver them, so their get out of jail free card is gone, right?
Right.
So I would say like less than 1% of notices to void that cite HOA docs actually have to do with the documents themselves. It's very low, and there's nothing that stops a buyer from voiding on HOA docs and going and buying the house next door, right? That has the same rules and regulations. There isn't anything that protects the seller, right? You don't have to say why. It's just, it is their, it's almost like their rescission period, right? It's their, oh, I made a mistake, right? Buyers are doing anything possible to win a deal. And so they make bad decisions and offering too much money, waiving contingencies, whatever. They ratify, they sleep on it, and they're like, I changed my mind. Now, lots of you guys know that I wear this bracelet every day, and it says, because I said I would. I don't know if you guys can see it at home. People don't honor their word anymore, much less what they sign on a contract. And the HOA docs really is something that I think is being abused a little bit right now. So just a soapbox moment. All right, property condition. Property condition, remember this is from the seller, right? The seller acknowledges that the broker has informed the seller of their rights and obligations under the Virginia Residential Property Disclosure Act. Okay, this is going to be the second place where this seller is acknowledging that they have been informed of their rights and obligations under the Residential Property Disclosure Act. All right, this is the first place. The second place is on the one-page Deport Disclosure document that I will show you shortly. Remember, how do we prove that we've given our clients the information on their rights and obligations? Well, we're giving them that 4-page Deport form, okay? Are they exempt from the act, yes or no? There are a handful of reasons that a seller could be exempt from the Deport Disclosure Act, and most of the time your clients are not going to qualify for that. It would be if it is a court-ordered sale, so like a bankruptcy judge is directing it and the court-appointed liaison is your seller and they have no knowledge of anything about the property. They've never been there. They're simply somebody sitting in an office somewhere handling this. If it is an REO, so real estate owned is what a foreclosure is called once the bank actually owns the property again. So after they have gone through the process of selling it on the courthouse steps and now the bank owns it, it's an REO, they are exempt. Because again, it's an asset manager who is sitting in an office somewhere in another state who is directing the sale. They have no knowledge of anything on the property. If it is an estate or a trust, they could be exempt if the trustee or the executor of the estate has no knowledge about the condition or anything about the property. So if I was selling my parents' property when they passed away, and it was a home I grew up in, and I'm the executor, I'm not exempt because it's an estate, because I grew up in the property. I know everything about the property, okay? Same thing if it's a trust. If the trustee who's selling the property is actually living in the property, they're not exempt, okay? So it could be a situation where they're exempt, but in most cases, what you're doing, the seller is not exempt. The seller acknowledges that the broker may receive from the seller or otherwise reports, surveys, plats, inspection reports, appraisals, homeowner or third-party warranty information or other documents pertaining to the property. The seller acknowledges the broker is required to disclose to prospective buyers all material adverse facts pertaining to the physical condition of the property actually known by the broker, including any such facts contained in property reports. Broker shall not, however, be obligated to discover latent facts in the property or advise on the condition matters outside the scope of the broker's real estate license. Okay. So what does that mean? That means you're not a home inspector, okay? You're not required to go through the home and look for things that are wrong to then disclose to a buyer when they come through the house. But if you know that there's something wrong, you have to disclose it, right? So the seller doesn't have to disclose, you have to disclose. This is where it's actually in writing for the seller that you have that disclosure obligation. All right, lead-based paint. Seller represents that the residential dwelling was or was not constructed before 1978. Okay, this is confusing sometimes. If the property was built in March of 1978, it does not require the lead-based paint disclosure statement. It has to be before 1978. So year built has to say 1977 or earlier to require it. In 1978 does not require, okay? There is a separate document that I will show you.
Wait, Shannon, what about January and February of 1978?
If it says 1978, it does not require.
I'm sorry, you said if it's before March of 1978, then it does apply.
No, March was just a random date.
Oh,
right?
okay,
So
I'm sorry.
So through December 31st of 1977. So if the date is 1978, then it does not require it.
Okay, got it. Thank you.
Yep. Okay, current liens on the property. This section is important. So as I'm reviewing your listing agreements that come through, I've highlighted a couple of things so far that I look at when you guys send documents to me. I'm looking for expiration, right? The term of the agreement, I'm looking for a price, I'm looking for your compensation so that we have a legal document. I'm also scanning through this section to see whether the appropriate boxes are checked or not. Because if certain boxes are not checked, then we may not be able to list the property. Okay, so be very diligent in having conversations with your clients about this section. The property is not encumbered by a mortgage or deed of trust. It means there's no loan, right? They paid off their mortgage. They paid cash or they've paid off their mortgage. Okay, you would check that box if there's no mortgage. If there is a mortgage, you skip that box and you go to section B. There is a mortgage. Check the box, and then you put in the appropriate information. If there's a second mortgage, right, a second trust, you check box C. If there's a home equity line of credit, you would check box D. So the difference between a second trust and a home equity line of credit is a second mortgage is a fixed rate loan, right? They don't get to use it like a credit card, right? It's just a fixed loan that they make payments on every month. A line of credit is like a credit card, okay? Now, here's the important part. I want to see E through I checked. That makes me very happy, and then I can move along. If any of these are not checked, I stop for a minute, and I may or may not sign your listing agreement. I probably will reach out and say, hey, what's the story? Seller is current on all payments for the loans identified above. We want that checked. Seller is not in default and has not received notices from any lien holders of any loan identified above that they are in default, right? Or notices of foreclosure. There are no liens against the property. Yes.
What if they have gotten a notice of foreclosure? They can still sell though, right? So what if this box was checked?
Well, so if that box was unchecked, then we would have a discussion because there's probably payments missed. And so the amount that's due, it could be more than what they've told us. And they might have a limited amount of time for us to get the home sold. So there's additional questions that I would want to make sure you have the answer to. So that's why I said we may or may not be able to sell the property.
Okay. Shannon?
Yes.
This is Kim. I have a question because of the whole forbearance situation that people are in. And because of what I've experienced, I mean, is that going to be a checkbox that can be added to this form? Because, you know, I feel like my client felt like they weren't lying to me. I felt like they were lying to me because they said, well, we technically didn't miss any payments. But
well, they did miss payments. They did miss payments. And so their box E would have been, should have been left blank. And so they did not tell the truth.
Okay. So, and do we have the right to ask for a statement, a current statement? Because that's what I've been doing. I'm like, can I see your current statement, please?
Yes, we absolutely should be asking for the statement so that we can do their net sheet for them. And when we got, I don't know if we got their statement or not, but we got their payoff and it showed when their last payment was made. And when we looked at that payoff statement for them specifically, it showed that they were not current because it had been a long time since they had made a payment.
Right.
Yeah. And so that's why we ask for the copy of the statement. because then we're going to see when their last payment was made, and then we can actually calculate an approximate payoff balance because it's the principal balance plus whatever their payments are that they haven't paid.
Yeah. Okay. Yeah, but we didn't get that payoff until a few days before closing. So that's what I want to avoid. Yeah.
Yes.
Okay.
Yeah. Yep. Absolutely.
Okay.
So the notices of default, we would of course want to know if they've received anything like that. If there are any liens for property on the property for federal, state, local income taxes, any unpaid real estate taxes or HOA fees or special assessments, we want to know that up front, right? We need to know that when we do their net sheet too, right? We calculate all of that in for them. Any judgments against the seller or sellers, this could be for anything, right? Any judgments that are attached to the property, because those bills essentially have to be paid at closing, right? Now, there are some waivers, and this is going to get a little technical for you. And so this is when you would call David Robertson or John McLaurin and ask for information. You would have your client talk to them, and then you would verify the information. If the home has title held by tenants by the entirety, so as husband and wife, and there is a judgment against one of the parties, and the judgment was put on during the time that they owe for a bill that they owe was incurred while they were married, then they can't really attach it to the property. Okay, so there are some waivers for that, but if it's held as joint tenants or in any other way, then that bill has to be paid. Okay, so it's only in tenants by the entirety that there are some waivers because of the ownership is 100% for each person when it's tenants by the entirety. Okay, it's not split in percentages. Seller has not filed for bankruptcy protection under federal law. This is a big one. This is a big one. We can't proceed with listing the property if they have filed for bankruptcy protection. And once it goes all the way through and the property has been released from the bankruptcy courts, then it can be listed. But so there's a lot of technical things in there. Okay, so this is important. Seller financing, does the seller agree to seller financing? I've probably only dealt with 2 seller financing things my whole life. If the seller is going to do seller financing, you're going to hook them up with UT, and the attorneys are going to take care of the note for you on that. Very rarely does the seller have the ability to be the bank. Right, in most cases, the seller doesn't have the cash for that. Closing costs. There are closing costs for the preparation of the deed of conveyance and the portion of the settlement agent's fee billed to the seller, the costs related to releasing the existing liens and encumbrances, the seller's legal fees, grantor's tax, etc., will be paid by the seller unless provided otherwise in the sales contract. So what does that mean? Well, sometimes the buyer offers to pay for some of the seller's costs in order to win the deal, right? We've seen in the last few months where a buyer agrees to pay the seller's grantor's tax, right? Just as something, a little extra to win the deal. The seller's estimated cost of settlement form is or is not attached. That's your net sheet. If you mark it is attached, then it needs to be attached when you submit it for my review in command. Okay.
Will we get that from
the net sheet? No, the net, that's something that you provide.
Oh.
Mm-hmm. Seller's proceeds. The seller acknowledges that their proceeds might not be available at the time of settlement. Why are they saying this in here? Well, because at settlement, we're a wet settlement state, meaning the ink is still wet on the paper and the seller gives the keys to the buyer, right? That's why they call it a wet settlement state. So as long as the buyer has delivered all of their money to the title company, then and everything is signed, then everyone has performed and the keys go to the buyer and the buyer gets to move in, even if the deed has not been recorded yet and the money has not been dispersed. So the title company has 48 hours, 2 days, I believe, to disperse, to get on record and disperse after closing. So it's not always the same day. They try. UT is very good. Most of the courthouses that we work with are electronic. So if you're closing in the morning, they will try to get on record and disperse the same day. If it's a Friday afternoon that you're closing, it could be Tuesday before you get your proceeds, if you are a seller. Yes, Mary.
Is any way the seller will not attend if he is in another country?
So Mary's asking if there's a way a seller cannot attend closing. So there is a way that the seller cannot attend closing. They can sign with a notary or a power of attorney. So depending on where they are, the documents can be sent to them and they can sign with a notary and then overnight the originals back.
And the buyer as well. I mean, if the buyer is not here as well, we can do this in another.
And the buyer, that's more directed by the lender, whether the lender will allow that to happen. You're welcome. All right, IRS and FIRPTA. So this is where you're going to determine whether your client is considered a foreign person, right? They put it in quotes, a foreign person as defined by FIRPTA. So this basically means not a US citizen by IRS tax law. So non-US citizens can own property in the United States, and FIRPTA was put into place so that taxes could be still collected when the property is sold. This actually is a burden put on the purchasers in the eyes of the law, because if it is someone who is not a US citizen, then they sell the property. How are they going to collect money from someone who's not a US citizen, right? Well, they're going to collect it from the buyer who's buying the property. So it has to go on the settlement statement. And if there are not enough proceeds, there's not enough cash, right, from the proceeds for the tax to be withheld, then the buyer has to pay it. So that's why it has to be disclosed up front. And that's why it's in the contract to disclose whether or not the seller is considered a foreign person as defined by FIRPTA. And there's a document to go through if the seller thinks that they are considered a foreign person for tax purposes. And then there are some exemptions, and the title company can go through those exemptions with your seller to see whether they would be exempt from the withholding.
So for this foreign person, would be basically in most cases like not a US citizen?
Correct.
Okay.
Correct.
Okay.
All right, sellers, representations, and warranties. Okay, so these are just some disclosures from the seller. So the seller is saying that they have the capacity to convey good and marketable title to the property by general warranty deed, and they are representing that the property is insurable by licensed title insurance with no additional risk premium. Okay, so what they're saying is they don't know of any issues on title. Right? They're telling us up front that they don't know of any issues on title that could cause additional premiums or costs to the buyer when they get title insurance, and that they have the authority to enter into this agreement. Okay? The seller is not party to a listing agreement with another broker for the sale, exchange, or lease of this property. No person or entity has the right to purchase, lease, or acquire property by virtue of an option or right of first refusal or otherwise. Okay, so why is that there? Because if we're listing the property for sale and then somebody swoops in and says, hey, wait a minute, I have first right of refusal, or I'm the tenant and I have a lease option to purchase and I wasn't given the option to purchase yet, and now you have a listing agreement, like what's the deal, right? We need to know ahead of time. And then the seller has to disclose whether they're a licensed agent, active or inactive, because that goes in the contract. The seller has or has no knowledge of the existence, removal, or abandonment of underground storage tanks on the property. That would require additional disclosure if they know of abandoned storage tanks for, like, you know, gas, propane, those types of things. Those are old storage tanks. Property is or is not tenant occupied. That also is important because leases are liens on the property and they convey. So buyer buys property, settles October 1st, lease doesn't expire until May 31st of next year. New buyer cannot come in and serve notice saying, hey, tenant, you gotta go because I want to move into my house. Okay, they have to honor the lease. This also would affect a buyer's ability to get owner-occupied financing. Okay, you can certainly sell a property that has a tenant in it, but it would be subject to the lease, and then it would be sold to an investor, not to an owner-occupant. And then the seller has or does not have a recording system on the property. So if there are recording devices on the property, then that must be disclosed. All right, because anything that's said or seen, right?
Would that include like the ring doorbell?
Yeah, so the ring bell is obviously seen by people that come in. So I don't think you have to worry about if you don't put in every listing that the ring bell, right? Because they're walking past the ring bell as they come in and it's right there in your face. It's very obvious. But I would say if you have a camera in the back, if there's anything in the home, or if the ring bell is not in a conspicuous place, right? Like I know that there are some that aren't like right there at the door handle. They don't use it as the Ring doorbell. They use it for motion detection. So then I would say absolutely you need to disclose it. Access to the property, the seller shall provide keys to the broker for access to the property. The seller will allow the broker's unlicensed assistants in the property to perform ministerial acts as defined in this section of the code that's quoted there. So as a best practice, what I have always done is obtained 2 sets of keys from my sellers. I take one set of keys and it goes in the lockbox. The second set of keys goes in a lockbox that I have, right? Not a central lockbox, but a regular like metal lockbox, right? That has a key. That way, if an agent loses the key, right? Accidentally locks the key inside the house, I have a key. I can go get in the house. I can help my seller. I have had many occasions where agents don't pay attention. They lock a garage door, then my seller can't get in. I can just grab my key, run over, not have to worry about the lockbox. Unlicensed assistants can go into the home, right, to refill brochures, set up for an open house, those types of things. Unlicensed assistants do not have access to central lock, so they cannot take their agent's central lock key and go and open the lockbox to get the key out to go into the house to set up for the open house. So they need to have access, so they take the key, right? So there's many reasons why having a second set of keys is a good idea. Yes, Mary.
Some listing agents depend on the electronic pad on the door only and give you the code to get in. But of course, I was having closing last week and no keys. So the buyers got upset. There is no keys. He said, no keys. Only you have to go with the code. I said, I have to deliver keys to my buyers. So I urged him to change this and to give me a couple of keys for the house. Okay, so Mary had a situation where were not keys. It was a code on a keypad on the door. So there's a couple of things I will say about that. If it is your listing, have the door handle switched out before you go on the market, so there are keys. I think that it's insane that a listing agent and seller would be giving out a code like that to their front door to have buyers and their agents coming in and out. I think that's crazy, right? Second, if you are on the buyer side and that's the only access that there is to the house, the contract says the keys that are available, right? So if there aren't keys, there aren't keys. Right. So there wasn't, in this case, any keys for them to give you. So there isn't anything to force them to have done. Mm-hmm. It would be your buyer's responsibility to go swap out that door lock, okay? But if you're the listing agent, think it through, right? I've had 2 occasions where there have been keypads and I would not list the property until there was an actual lock that had a key. I just wasn't gonna do it. And that's the one thing that I will tell you guys is remember that, and this, I don't want this to sound like callous when I say it this way. You're not the puppet for the seller, right? You get to make decisions that are in the best interest of everyone, right? And you can say, we don't list the homes with doors that have keypads. You can say that. And you can use me as the bad guy and say, if they push back and say, my broker won't allow it, right? And I don't want you to lose a listing over it, right? But when you show your professionalism and you explain why, they're not gonna care, right? If they say, well, it's another expense. I just redid the floors and I, painted the whole house. And now you want me to spend $100 on a new door lock? And then you can say, how many, is it worth $100 to keep people from coming in and out of your house when you don't want them there? Like, come on, right? It's not good. It's not good.
I saw one that had like the code in the lockbox.
Yeah, but so now they know the code. Yeah. You think the agent's going to forget the code?
Shannon, I even had a situation where I had my sellers, we had a lockbox on their house, and in the middle of the day, their son was home alone and there were no showing appointments that day, and somebody went into their house and I was notified immediately, and I contacted them and said, is anybody home, because there's a realtor in your home? And they freaked out, which they had every right to do so. But yeah, had we not have a lockbox on there, I would have never known that.
Right, exactly. That's exactly right. So so having the lockbox, the central lock, especially when you're using the app, and I don't know if you guys know this, some of you probably know this, and this might be an aha for some of you for the end of class. When the lockbox is opened is not when you get the alert in your app, it's when the code is generated. So if somebody is using their card to open the box, you're never going to be notified. It's when they use the app and the code is generated to open the box. So if it's a Bluetooth box, right, it automatically is generating a code internally and it's opening the box. But if somebody is using their physical card to open the box, you won't ever be notified. So it's only when you use the app to generate the code to open the box. So always use your app and never use your card, because it's just better for our industry. But Kim, you're right. if people had just been, you know, able to punch a code in or a combo box, right? You guys remember how nice I was about combo boxes yesterday. But it's for everybody's safety, right? Nobody would know that somebody came in on the combo box unless you've got the Ring doorbell. And let me just tell you, I get alerts on my phone for every stinking car that drives by. But when the Amazon box is delivered to my porch, I never know. I don't understand what the deal is with my Ring doorbell. But yeah, yes. Raekwon said it's for my protection. My husband doesn't know that the Amazon boxes are coming. But so sometimes even the cameras aren't picking up things, right? So we need to just we need to use the technology for our best purposes. All right, assumption of risk. Okay, here's another important one. This may or may not be a good aha moment for you guys. I hope you guys are getting I hope many of you know a lot of this already, and I hope that each time you come, because I require that everybody come so many times and sit with me and make me feel important, that you get aha moments out of these. This next section talks about the assumption of risk for the seller, right? And so the seller is assuming all the risk, right? They're holding us harmless for basically anything that could happen unless it's our gross negligence and it's something that we did on purpose. So they're going to take their valuables out. They're going to take their weapons out. They're going to take their medication out, right? All of that. That's going to be part of your listing presentation, okay? The next section, though, talks about homeowners insurance, their property insurance. If the property is vacant, they need to call their homeowners insurance policy to the equivalent of a fire policy, right? There is a vacancy clause in their homeowners insurance that is essentially a fire policy because they have no belongings in the home. And if they don't notify their homeowners insurance company that the home is vacant, it could be considered abandoned. And if there is something that destroys the home, like fire or a leaky pipe or something, and they have been out of the home for a long period of time, their policy might not cover the damage. So now I'm going to look on the screen and see how many of you just learned something. All right, awesome. Yay, I'm so glad. So hopefully you got 2 things out of this morning so far. Yes, Gailey.
Gailey, I have just kind of a related question. I had this come up recently. I had a seller accuse my inspector of damaging something in the home and was asking us to repair it. We didn't, and she did end up repairing it, but it became an issue. What's the legal rule there?
So there's a couple of things. The inspector is considered an invited guest into the home. So I would not really go through the homeowner's insurance on that. I would go through the inspector's insurance if they're willing to escalate it to their own insurance. So home inspectors are required to be licensed and insured in the state of Virginia. And so that's the reason that they are supposed to be licensed and insured, is for the case where there is an issue. Now, proving who actually caused the damage is a challenge. I had a situation a couple of years ago where I got a phone call. I was the listing agent. I get a phone call from the buyer's agent and subsequent text messages with photos of a damaged garage door. And the agent is telling me, I'm so sorry. The home inspector damaged the garage door when he was testing it, blah, blah, blah. We're going to take care of it, right? And like an hour and a half later, the story changes. And oh no, He's not taking care of it. It's not his fault. He didn't do it. There was something wrong with the garage door sensor, whatever, right? The story changed. I fought hard on it, and I ultimately ended up getting the inspector to split the cost with me to fix the garage door, because of course the buyers put it on their HICRA, right? Like they wanted it fixed now, and their inspector did it. But it's really hard to prove, right, that the garage door was working just fine, although I had the text messages from their agent that said his inspector broke it.
So interesting, what happened with us was that I received a text from the listing agent after the inspection with a picture saying, my client, the seller, is saying that your home inspector broke this during the inspection. Mm-hmm. And he didn't break it. And basically what I said was, well, that didn't happen because I was standing there with the inspector the entire time he inspected that area. And he didn't break it. We were there together. So something happened after we left the home, something fell. Anyway, so I mean, that was basically, and the listing agent believed me. I mean, he said, I believe you. But it was really the fact that I was able to say, well, that didn't happen because I was there. I was there the entire time and saw it. And then basically she ended up having to pay for it because we were not going to pay for it. But if I hadn't, you know, I felt it was easy for me to stand my ground because I was actually there. Now, if I hadn't have been there, it might've been, I'm not sure what would have happened, but.
Right. And every situation is different, and it depends on, you know, what happened, how it plays out, right? I shouldn't have had to pay for this garage door. I wasn't there. I had nothing to do with it. It wasn't my inspector. It wasn't from my clients, right? But in the end, I wasn't going to let the deal fall apart over a $500 garage door. Like it just, it wasn't worth it. So I took care of it. But I didn't have proof that it was actually working beforehand. All I had was the other agent's text message saying his inspector broke it. So there are situations where, you know, things come up, and the assumption of risk is still on the seller when you're inviting people to come in the house, right? The showings are invited guests, right? They are invited guests into the property. You hope that they don't do something, but you never know. You never know. All right, miscellaneous section. So this is just going over some of the same things that we talked about yesterday on the buyer agreement. So seeking appropriate legal advice, the law, all of that is the same as the buyer's agreement. Binding agreement. This agreement is binding once everybody signs, right? So the same thing that we talked about yesterday, everybody signs, seller signs, I sign as the broker, and it gets delivered back to the clients. Put me in the same envelope as the clients, then you don't have to worry about delivering it back yourself, okay? Attorney's fees, same thing as on the buyer agreement. If somebody is at fault, the party at fault pays the attorney fees for the non-at-fault party. Okay, that is our listing agreement. I'm just gonna go through these last couple of things real quick, and then I'll show you the tax record and give you guys a quick break before we get into rentals. So this is the same ABA as we had on Monday, same cybersecurity notice that we saw on Monday, same 4-page Deport Disclosure as Monday. This is the 1-page Deport Disclosure. On this Deport Disclosure, this is where the seller is providing the document to the buyer saying, hey, buyer, I don't have to tell you anything. This is the buyer beware state. Go to this link right here if you want to read more, right? And it takes them to that 4-page document. If they have to disclose something, right, one of those 5 things, then you have to pull the document, like if they're in a military or installation, whatever, and it goes with this disclosure statement. property address and legal description go on this document, not one or the other. Property address / legal description. We talked about that on the first page where if it's a slash, you put both. Address and legal description go here, okay? The seller signs and dates first, and then the purchaser signs and dates. I do look at that. I do look at the dates. I look to see that the buyer signed after the seller. I'm not going to return it to you if it's dated backwards, but I'm going to notice. And if I see it happen regularly, then we'll probably have a conversation about how this Deport disclosure is being delivered, because it might appear that you're not obtaining the Deport disclosure from the seller side before you're preparing the offer. In a lot of cases, the Deport disclosure is in the listing. You don't have to track it down from the listing agent. It's right there in the listing in bright. Okay, this is also where you would determine the seller's names so that you verified that you put them in correctly. Okay.
Shannon, I have a question. I just want to go back to the ABA thing. It's not our ABA that I have a problem with, or AB, whatever. I was recently, I noticed that it's just, this is just our clients that we're getting this from, right? The people on the other side of the transaction don't have to sign that once we close, right? I don't see.
Yes, that's right. This is a disclosure from us to our clients because KW United has a business affiliation with UT that is financial. Now, there are a couple of companies that don't understand how an ABA works, and they send the ABA for everybody in the transaction to sign, and it does not hurt anything to have your client sign it. It's a nice thing to do for the agent on the other side, because the agent will likely not get paid because their brokerage doesn't understand how the ABA works. Okay. So you can go ahead and have them sign it. The only time that it is actually required that all parties in the transaction sign the ABA is when the parties, the agent has a substantial ownership interest in the title company, right? So the agent is having to disclose their personal interest financially in the use of the title company. Okay. In the transaction. Okay. So if I had a 10% or 5% ownership interest in Universal Title, and we were using Universal Title for the transaction, then I would need everyone to sign this agreement. And up here at the top, where it lists out how UT Falls Church Founders have 49.9%, it would also then list my name and the percentage that I owned. Okay, but if I don't own, I believe it's more than 2%, then it doesn't have to be signed by the parties. So every once in a while, you're going to see something that comes through that really does have to be signed, but it's not very often.
Okay, thank you.
You're welcome. All right, so that's the one pager. Useful information, same as Monday. Here's your lead-based paint disclosure. Here's the property address that goes at the top. And basically, this is the disclosure coming from the seller to the buyer saying that they are aware of a presence of lead-based paint or lead-based paint hazards in the home, or they have no knowledge of lead-based paint or lead-based paint hazards in the home. So they have to initial here and then check one of these boxes. Okay. Thank you. If they know of lead-based paint or lead-based paint hazards, then they have to actually say what they know about. The second section, they have to initial for B, and then they have to say if they have reports available or no reports available related to any lead-based paint or hazards in the home. And then the purchaser initials down here for C, D, and E. And on E, they have to check one, whether they received a 10-day opportunity to conduct a risk assessment in the home, to check for lead-based paint, or they've waived their opportunity to inspect for lead-based paint. And then the sales associates, both listing and buyer agents, initial, listing agent here, buyer agent here, and then everybody signs the bottom, okay?
Shannon.
Hi, Story.
Hi, how are you?
Good, thanks.
Going back up to the lead-based paint, just real quick on purchaser's acknowledgement initial for C, you wouldn't have your purchaser sign that if there have been no reports given. That's a question.
Right, so, right, if there's nothing that they've received, then they don't have to, there's nothing to initial, right?
Okay, thank you.
Sorry, Shannon, I have a question too.
Sure.
And I guess I always thought of C as saying that they received this, that they didn't have information, or that they saw all that. But so for the first part, for the seller, so you would put that there's, you know, the house is older, so the lead-based paint hazard. And if they have no knowledge, so that's saying that they didn't, there's like no testing that they've done. They actually are like, maybe there's there, but we really don't know 100% for sure. Is that what that is?
Right, if they have no actual knowledge, right.
Okay, all right, cool.
Yes, Mary.
So purchasers acknowledge initial, they have only to think on waive the opportunity to conduct a risk assessment. So the buyer agent will take this one only, she will not take any of the C, D, and E, right? If they will not receive any reports from the seller.
So so the only thing that can be skipped in the purchaser section is C. Right.
Oh.
There's the protect your family from lead in your home. We as the agent would provide to the purchaser or a link online to that. So they would initial that we sent them the link for that pamphlet. And then they would initial E in whichever box they check. Either they're going to do an inspection or they're not doing an inspection. Correct. Okay. All right, listing agreement amendment. So this document is what you use to make any changes to the listing agreement after it's been signed by the seller and me. So this is if you have to change the price, change the on the market date, change the expiration date, add something that conveys, take away something that conveys, change it to temp off, if you're withdrawing it or canceling the agreement, any change to the agreement at all. If you're correcting the seller's names, if I've kicked back the agreement and said, hey, the home's owned in a trust, and I need an amendment to the agreement correcting the seller's names, right? This is all done on this one document. So the amendment is made on whatever day you create the amendment. It's always going to be the exclusive right to sell listing agreement if it's for sale, or it'll be the exclusive right to lease agreement if it's for a rental. And they do make this available for the land listing as well, between the seller and the broker, and you put the address here in this section that is where it says property. And then when you look down further, it's fill in the blank. Is the listing price changing? Check the box, fill in the blank. If you're extending the listing period, check the box, fill in the blank. If you're changing the entering into the MLS date, you would check that box. Other, that's where if you're correcting the seller's name, if you're changing a conveyance, whatever the other changes you're doing. If you're putting the home in temp off status, you need a listing amendment. So you would use this document if you have to change it to temp off status, right? So we talked yesterday about how coming soon expires after 21 days and you might not be ready to be active. So it has to go to temp off. Withdrawn and canceled. The difference between withdrawn and canceled in the MLS is withdrawn means the listing agreement is still in place. So they are still under a brokerage agreement. So you can't call someone who has a withdrawn listing in the MLS and try to solicit that listing. If it's canceled, that means that the agent and brokerage has set them free and said, go and be happy with some other agent. We can't help you any further. If it's withdrawn, it means they are still under a brokerage agreement and you may not go behind the sign. Okay, so be very careful if you are setting someone free that you are choosing the appropriate choice. If you are taking something off the market to let it sit so that it can reset the days on market, you would withdraw. If you are just setting them free because you don't want to work with them anymore or they don't want to sell their home, you are canceling. Okay.
Shannon, I have a question on with the resetting the days on market.
Okay.
How many days does it need to be in withdrawn status to refresh
61.
the date? 61?
61. Yep. On the 61st day, you can re-enter it.
Thank you.
You're welcome. For days on market in MLS, they reset after 61 days.
You said
to zero.
To zero?
Mm-hmm. Yes. Sellers information for optional information on making an offer. Okay, this document should be used by every single listing agent ever. This is so helpful to buyer's agents. How should the seller's names be listed on the contract? What is the preferred delivery? So section 6 on the contract is delivery. So what do you fill in for the seller when you're preparing an offer, right? What do you put in for the seller side for delivery? This is, as a listing agent, you're telling the buyer's agent what to fill in there. I can't tell you how many documents I see that are blank, right? Because the buyer's agent doesn't even just fill in the listing agent's email address. FIRPTA, is the seller considered a foreign person? For FIRPTA purposes, is anyone on the seller side a licensed party? Right, this is all important information to know as a buyer's agent when you're filling out that offer. The property information, this way you don't have to go into the tax record. I think you should always double check, but it's being filled out right here. Is it a condo, HOA? If so, what is it? Is it built before 1978? Utilities, right? What do you fill out in that utility section? And then it even goes on to say who the utility companies are. So if your buyer is the winner, then they know who to call to set up their utilities, right? You're asking the seller up front, you know, is it Dominion Power? You know, is it Washington Gas? Who is it? Who's your propane company? Is it Holtzman Propane? Like who owns your propane tank? And then the conveyances, so they know exactly how to fill out the conveyance section. And then listing broker information. So this is all of your information for the buyer's agent to fill out on page 13 of the contract. I will tell you that if the listing agent doesn't give this information to you, you have access to all of this information, so you can fill it out. You can fill it out completely. You just have to look a couple of different places. You have to go into Deport, and then you have to look a little deeper in Bright to get this information, but it is there for you. But as a listing agent, it's nice to provide it to the buyer's agent. Seller's preferred timing for closing. Do they need a rent back? This is also where you would put if they need home of choice contingency, if there's a septic system. When we get to that in the offer docs next week, you'll see that the septic inspection actually gives the option that the seller provide the septic inspection report to the buyer instead of it being a buyer reported inspection. So all of these things are here so that you can help the buyer side make an appropriate offer to your seller. And if you're a buyer's agent, always look for this document in the MLS, because if you fill things out appropriately, it's going to make a good impression on the listing agent. Well, it's in your NVA forms library, NVAR forms library. It's an NVAR document.
Nice.
Yeah, NVAR provided this to us in April of last year. Yep. All right. Suzanne.
Could I make a comment?
Oh, yes, Alicia.
I just want to stress the importance of being nice to all the buyer agents out there and filling this form out. Please, 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 please. It just will save everybody a bunch of headaches with, going back and forth to correct the conveyances, especially the little bitty stupid things like that. It's such a nice detail to have, and you look very professional, I think. So.
Yes, I agree. Suzanne, you have your hand up?
Yeah, yes, hi. Yeah, so can farm members use that? Because I was gonna use that form, but it specifically says for NVAR members.
So all of the FAR members are actually members for documents of NVAR. So all of the Fredericksburg office is supposed to be using NVAR documents.
Okay.
Yes. So you have access to that forms library.
Okay, thank you.
Actually, all of the documents, except one that we have reviewed this week, are NVAR documents.
Okay, thanks.
You're welcome. Mustafa.
I just had one listing. So my experience was on that listing, and I had 3 offers that came, and I had this sheet there. And, I assumed that they're going to follow those and, take those information, put it on the offer, but pay attention on those information as well, because 3 offers that I got, none of them was correct. And even though this paper was there, but they just scramble something and put it over there to submit the offer rather than put in all the information. And sometimes we get excited, we look at everything else except those information that need to be done.
Right. Yeah, it's important to look at the information that the listing agent provides, because there might be some key detail that matters to the seller that could cost your buyer the offer. Absolutely. All right.
So you guys should all be really grateful that Shannon pointed this form out, because the first time I came across this form on a listing, I was like, oh my gosh, this is amazing. And I thought that agent had made it. And so I was like, I'm going to make this. And I went in and tried to make this form. And then I noticed at the bottom, it said NVAR. And I was like, so it was very difficult to try to make. I don't suggest it. So thank you, Shannon, for letting everybody know that it is available on the NVAR forms. Learn from my mistakes. Don't do it.
Yes, that little tip at the bottom left-hand corner that says where the form came from is huge. Awesome. All right, I'm going to give you guys a little break. We'll come back. We'll look at the tax record, and then we'll talk about rentals. Okay, so it is 10:18. Let's come back at 10:25.
You're on mute, Shannon.
You muted yourself.
Okay, well, that was not good. So what I was telling you guys that you couldn't hear me was that the computer is frozen on that screen that I just showed you. And I've called in Melinda to come back down and rescue me. And hopefully the computer here in the training room decides to be untired very soon and I can show you the tax record. But in the meantime, I'm going to show you some rental documents so that we can make the best use of our time together this morning. So day 3 is what we are going to start with right now. And I will reshare my screen on those documents. Okay. So our landlord and tenant packages have very similar documents to what we have reviewed thus far when it comes to buyer and listing agreement documents, with a couple of exceptions. I don't have these, it looks like, in a great order, so I'm going to scroll through and show you a couple things, and we're going to do the lease last. So I don't know why that I had that first, but we're going to do that last. Okay, exclusive right to lease listing agreement. Let's look at that. So that should be your third, maybe 5th document in your package. The exclusive right to lease listing agreement has many of the same components that the listing agreement to sell has that we just talked about. So I'm only going to highlight the things in this document that are different from what we just went over. Okay, so appointment of broker, premises, notices, all of that's the same. Term of the agreement, if you don't put an expiration date, it defaults to 90 days. Section 5 asks about the lease terms. So you're going to talk to your landlord client about the minimum and maximum lease term that they are willing to have a tenant come in for. Most of the time we're seeing a minimum of 12, a maximum of 24, right? That's pretty standard for what the landlords are offering. Sorry, Vidya, the links that I've put in the chat the last 2 days to the Google Drive have all of the documents for the entire week. Do you still have access to that?
No, I don't.
Okay, guys, bear with me for just a second and I'm going to put the link, let me stop sharing, back into the chat for our documents for anyone that does not have them for this week. I'm not resending the email each day. I just, I sent the one and then have put it in the chat each day. Vidya, I'm going to ask you to download all of the documents for each day so that you have it for the rest of the session. Okay, there's days 3, 4, and 5 when you go into this one link. Okay, for anyone that needs the documents, they are right here in that link. Okay. So back to the lease terms, minimum of 12, maximum of 24. It can be minimum of 12, maximum of 12. They can offer short term. It's whatever the landlord wants to advertise. And then there's a section in the listing when you enter it into Bright that you can put that in so that the prospective tenants and their agents know what they're looking at. The price This is where you're going to put the advertised listing price, how much per month your landlord wants you to offer the property, and then what day the property is available for occupancy. It's currently rented. I would say don't put this the next day after the current lease expires. You want to give it some time before having the new tenant move in so that everything can be cleaned and any repairs can be done before the new tenant moves in. The worst thing that you can do is to put a tenant into a property that is dirty and not ready for the new tenant to move in, because you want them to leave it as they found it. Now, the next section is a disclosure from the landlord on their ownership interest in rental properties in Virginia. This, for those of you that have been in the business for a while, this paragraph used to disclose how many properties they owned for the sake of determining whether they were going to use a VRLTA lease or a common law lease. There is no such thing as a common law lease anymore in our forms library. We are only using VRLTA leases, and everything is governed under the VRLTA in Virginia. There's just not a difference really between common law and VRLTA anymore, so everything is under VRLTA. This paragraph is asking for the disclosure of how many properties the landlord owns for the sake of being able to decline Section 8 vouch and housing vouchers. Okay, if a owner has less than 4 properties in Virginia, they do not have to accept housing vouchers. So this is where the disclosure comes in. Yes, there is an additional fair housing category that says anyone who, that no one can discriminate based on source of funds, right? It's not source of income really, it's source of funds. And Section 8 housing vouchers would be considered source of funds. So how can they discriminate? Well, this is an exemption because someone who owns less than 4 dwellings that are for rental purposes isn't running a business out of it necessarily. If they own 4 or more, they're running a business. And so they cannot exclude the Section 8 vouchers as a source of funds to pay for the monthly rent. Now, let's just talk from a practical standpoint when it comes to the housing vouchers. We have property management companies that are within our market centers. PPM in Fredericksburg is one of our property management companies, and I, as the broker for the market centers, oversee that property management company. We have excellent luck with the tenants that have vouchers, okay? We get payment regularly and on time from the government entities that are paying the voucher payments to us. We have individuals who do not have vouchers that don't always pay on time, okay? So there is a level of stability when it comes to the voucher payments that you don't always get with individuals. So I will just throw that out there when you're having conversations with landlords on whether or not they would like to consider someone who is receiving a voucher as part of their payment. The vouchers are, the money's not paid to the tenant, and then the tenant pays the landlord. They are paid, the money's paid directly to the landlord. And then depending on the situation, sometimes the tenant has to pay a portion on their own, and sometimes the county or the entity pays the whole thing. The tenant still has to qualify, right, on the rest of the application. So it's not like they just, you know, because they say they have Section 8, you know, they automatically get in. So I just wanted to have that little conversation. I guess it's a plug to consider vouchers, right? And not just automatically decline. My hero just came back to fix the computer again. she's probably gonna like block my phone number. Yes, Mary.
If the owner has less than 4 houses, they accept or not accept?
Well, there's a checkbox. Yeah. So they have to check the box.
Either accept or not.
Right. When we go into page 2, the landlord will allow smoking, yes or no? Will they allow pets, yes or no? Are there restrictions on pets? Make sure if it's a condo that you're checking with the association to see if the condo association and the buildings allow pets before you start advertising if pets are allowed, because there could be a situation where your client doesn't care if they have 4 dogs, but the building only allows 1. And then yes.
Quick question, going back to the less than 4 rental properties, is it not better for the landlord to accept a voucher even if they don't have 4 properties or less?
Yes, that's what I was saying, is that I would think that it's better to consider all applicants regardless of whether it's a voucher or not, because vouchers are stable income. And then the deposits that are required from the tenant based on those pets. So what would a deposit be? I think $250 per pet is what my clients have charged. And deposits are not non-refundable, okay? So don't make the mistake of saying non-refundable deposit. If your client wants something non-refundable when it comes to the pets, it's a fee. It's not a non-refundable deposit. There's no such thing as a non-refundable deposit. It would be a fee. If there's a fee or a deposit, it needs to be disclosed in the listing. Yes. All right. The next section is on property and fixtures. So this looks just like our conveyance section in the listing agreement. So this is what is in the property, right? What is going to be in the property when the tenant moves in? Is there anything as is so that the landlord is not going to warrant the condition or working order? So why is that important? Well, it's important because if it breaks, thank you. If it breaks, the landlord does not have to fix it, okay? Everything else in the property, if it breaks, then the landlord would have a level of responsibility to fix it. So as an example, let's say there's a second refrigerator, okay? They've put the old original refrigerator from the house in the garage, and there's a main refrigerator, obviously, in the kitchen. Well, they could say that as is would be the second refrigerator in the garage, that if it breaks, they're not replacing it. It's just going out, you know, to the dump. That would be an example. Maybe they're leaving their lawnmower, right? And the tenant is going to be mowing the grass. But if the lawnmower breaks, then the tenant's going to have to buy their own lawnmower because it's their responsibility in the lease to take care of the grass. All right. Utilities. This is where you are filling out what type of utilities are in the property, and this gets missed all the time. This section right here on the right-hand side, where you're marking whether it is included in the rent. So does the tenant have to pay separately, or is it included in the rent? Please mark that. Bless you. All right, the next section is just reminding everyone that the premises are subject to VRLTA and the broker shall only provide the VRLTA lease, which we will go over. The broker's duties, these are very similar to in our regular listing agreement. Okay, we're looking for a tenant, we're gonna market the property. We're going to show it at reasonable hours to prospective tenants. We're going to account for all monies in a timely manner. In this case, we do collect money on behalf of our landlords, right? When it comes to EMDs for contracts for our buyers, we don't hold EMDs. We do collect money on behalf of our landlords, okay? So the first month's rent does come to the brokerage. There is a box here to say whether we will install a lockbox, yes or no, and will we put a for rent sign out, okay? They're telling us whether we're allowed to put a sign out. This is the same exact verbiage for the internet MLS marketing as in our for sale listing agreement, where we're saying when it's going to go on the market. And if they're not authorizing us to put it in the MLS, then they have to sign the waiver. Are they authorizing? Yes, Alicia.
Thanks. Could I just back you up to H again? Just to clarify, I haven't done one of these before, but I've been doing, you know, tenant on the tenant side. But when I do come to it, do we as a brokerage accept wire transfers for that first month's rent?
We do.
Okay. And that was kind of a frustration of some of my tenants, because they would, you know, have to like go to somebody's brokerage to hand them a money order rather than just wire them the money. Not our brokerage, another brokerage and other brokerages. And I was just wondering, is that is that something that we choose to do, or is that something that is, you know, could be across the board with every brokerage?
Yeah, so every brokerage is different. Some might not want to accept wires because it's hard to match up. When wires come in, just so you guys know, when wires come in, we don't have any information that goes with the wire. It's just an amount of money. Okay, so if you guys have not turned in any documents for us to match anything up, then it's very hard for us to know who that wire is from. And that could be why some brokerages don't accept wires, because if we get a cashier's check, then there's going to be somebody's name and address, and you know, it's going to be a little easier to track. We will accept the wires because we will work and track it down, right? Our MCAs know that I love to use my Sherlocking skills, and when they can't figure out where the money goes, they'll send me a list and then I Sherlock it. And if I can't, that's when the email will go out to the market center and say, hey, who does this money belong to? Very rarely will you guys see those emails, because I like to do that. Although I don't like to do that, I like it when we actually know where the money belongs. Let me clarify that. But I don't like it when we have to send the emails out.
Okay, thank you.
It's already required to put a copy of first month's check and deposit. It's required.
Okay.
So we have to have actual picture of that first month. And
okay, so Mary's asking a question about what do you put in command, because the checklist item says a copy of the first month's rent. So you can get an email from our MCA that confirms that we have received the wire, and that would go in the first month's rent section. So the reason that I ask for a copy of the first month's rent is to see who it is that we are expecting the commission from. So if we're on the listing side, then we should have the first month's rent, and I should be able to verify that we are holding the first month's rent and that it wasn't accidentally made out to the landlord or someone else. When it's us on the tenant side, I want to know who the first month's rent was paid to, so that we know who we're expecting to receive the commission from. So if it's a wire, it's just like the earnest money deposit. When it says proof of delivery of earnest money deposit, I don't want a copy of a check. I want to know that the earnest money deposit was delivered to somebody and who it was delivered to and when it was delivered, right? So I want to know where it is. I want to know where the money is. Yes, it will.
Because in the documents, we have a certain format to be able to upload.
PDF.
Oh,
you just, PDF is the format. So you just save it as a PDF.
Oh.
Mm-hmm. Yep.
Hey, Shannon, before we even accept this check, they have to go through the application process, right? The tenants, and who do they go through?
So I'll show you the application when we get there.
Okay, thank you.
Okay. All right, so this is the authorization for third-party remarks and address and everything, just like it was in the listing agreement. And then this is the coming soon section right here, section D, that says whether or not it's going to go in coming soon status. And just as a reminder that rentals fall under the Bright MLS rules for pre-marketing. So you may not advertise a rental more than 24 hours before it goes into the MLS. So $5,000 fine on a rental is not worth it. It's really not worth it on a sale, but it's really not worth it on a rental. The next section here is undesignated and dual. I see more often than not agents that are trying to do dual on tenants, landlords and tenants versus on sales. So just remember, leave the other party as unrepresented. You'll be much better off later, okay? Yes to designated, no to dual. Compensation, okay. So this compensation section, I see anything around 1 month's rent, right? Because we are collecting 1 month's rent up front from the tenants when they submit their application. So I think that's why we just happen to have the payment as 1 month's rent. You have to decide for your business what you're going to charge your landlords. It's not going to be less than 50% of 1 month's rent. It could be more, but it's not going to be less than 50%. But 1 month's rent is how much we collect from the tenants when they submit their application. And that's what you would put in this line if you're charging 1 month's rent. And then that next line that says compensation is also earned within blank number of days after expiration, right? That's just like the listing agreement. So 30 days, 60 days, whatever you want to put there. And then section B is the co-broker compensation. So that's when you're offering out to the tenant's agent a portion of your commission if there's a tenant's agent. I see 25%, 35%. Occasionally I see 50% or 40%. I don't really see anything less than 25%. Sometimes I'll see a flat fee in the MLS. But I don't generally see anything less than 25%. Retainer fee. So this is one that I know a lot of agents would like to charge retainer fees. My personal opinion is it's not worth it. It's just not worth it to go through the headache of trying to charge a retainer fee and then have it applied, and just vet your prospective clients, right? Just vet them properly before you go waste your time. And if they are wasting your time, then cut them loose and call it a day. Early termination, again, this is the listing agreement. So actual costs, right? Purchase by tenant. Okay, so in this case, purchase by tenant means the tenant moves in, after a certain period of time, they decide to buy the property. you could be considered the procuring cause, right? Because without your rental listing, this tenant would not have known about the property, right? So how much are you going to charge the landlord if the tenant buys the property? That's what goes here. This is only related to you and the landlord. This has nothing to do with the tenant's agreement with their agent on how much they might have to pay their agent, right? This is not like a total of 6% with 3% being offered to the tenant's agent, right? There's no co-broker compensation. This is simply between you and the landlord, how much you're charging, okay? It doesn't have to be 3%. I think 3% would be pretty steep considering you didn't actually have to market it or do any work. That's just my opinion. You know, 1%, a flat fee, something like that. Think about your business practice and how much you would want to charge them, okay? Now on the flip side, if you had it listed for sale, right, at the same time as having it for rent and it was listed for sale for a while, and then they ended up renting it because they couldn't sell it because they weren't listening to you and doing what you told them to do, then maybe those cases you would have a different fee, right?
I have a question. I've seen rentals for sale and for rent simultaneously with different agents. Why different agents? I've seen that a couple.
Okay, yeah, so Alyssa is saying that she has seen properties that are listed for sale and rent at the same time with different agents. Why is that? So first, just to clarify, it is okay for that to happen because it's different services being provided. So you are allowed to do that. And it could be with different agents because the one agent who they engaged first doesn't do the other service, right? So some agents that focus in sales are too busy to do a rental. So that's probably why. Yes, Mary.
Purchase for tenant. If you didn't know about this term before, and really your client is planning to buy a property I rented to them, and we have this discussion with the landlord already that after 6 months we are planning to buy. So if I didn't put anything here.
So this is with the seller. This is with the landlord. This has nothing to do with you and your tenant. Okay. This is for the landlord who's the seller right now that we're talking about. Okay. All right. Confidential information. This is the same paragraph is in all of our agreements that we keep confidential information confidential unless we have permission to share something with the other party. Authorization to disclose applications. This is just like if we are taking multiple offers on a sale. Compliance with fair housing laws. We have to comply with fair housing laws no matter what our clients say. Relo program. Is there a relocation program? Not usually with rentals. Is there an HOA or a condo association? This is important because the tenants have to comply with the rules, right? And the landlord has to provide the rules to the tenants. In the case of rentals, it is okay to have the landlord go ahead and order or get access to any of those documents, to provide to the tenant. Right now, there are a lot of like online portals that landlords have access to that then they can get tenants access to. And so I suggest letting the landlord sort of take the lead when it's a rental on getting access to these, because the landlord is the only one that can actually get access for the tenant. We can't do that on behalf of the landlord. Lead-based paint disclosure. There is a lead-based paint disclosure for rentals, and it looks exactly the same. It's just got a couple of different words on it from the disclosure that we just went over. And then the liens. We need to know about certain situations or the landlord. So in recent years, when we had a lot of properties that were distressed, right? So landlords, homeowners were behind on their payments, or they wanted to buy new homes, they would get a tenant in so that they could offset that mortgage payment to be able to buy something bigger, and then they would just stop paying on the other loan, right? This was part of the mortgage crisis. This was part of when the bottom fell out back in 2008. And then there was a secondary crisis, right, of unintended consequences of what to do with all these leases, right? All these people that had rented properties, and then now the banks own them. So now the banks were landlords. And then did the banks have to honor, et cetera? So we need to make sure that when we enter into rental listings, that we are entering into these with landlords that are current on their payments, and that they haven't received any default letters from their mortgage companies if they are, if they have mortgages, that there aren't any liens on the property that could result in a foreclosure by the lien holder, right? IRS liens, tax liens that are from the state, HOAs can actually foreclose. We need to make sure that there's nothing that's gonna cause an issue for the tenants. All right, landlords warranties, very similar, just slightly different words. Landlord's not a party to any listing agreement with another broker for the sale, exchange, or lease of the premises. Okay, so what if they are? That's okay, they have to tell us, right? They have to disclose it. And so then we would disclose it in another section. No person or entity has the right to purchase, lease, or acquire the premises, right? Are they licensed, active or inactive? Are there storage tanks? Is it currently tenant occupied? If it's currently tenant occupied, I will suggest that you make very nice with the current tenant and talk to the current tenant about how showings are going to go. You want the current tenant to be your friend because you want them to let people in and you want the home to show nicely. Okay, it's not, yes, Raekwon.
That was going to be
okay, it's not required that the tenant move out before you start advertising, right? It's not necessarily suggested, like I strongly suggest, right? You guys know my suggestions, that you get the tenant out before you sell a property. To go from tenant to tenant is very different. But if you make friends with the current tenant and everything is nice, then they will be nice to you and they will be accommodating. If you just say, the lease says that we can have showings within 60 days and blah, 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 and these are the hours and anybody can come whenever they want to, then it's not going to be pretty. But if you say, we normally have a 2-hour notice and this is the window of time, does that work for you? And what's the best cell phone number for the showing company to text you so you can confirm the showings? And enough? Do you need 4 hours? And be aware that sometimes agents will request it, within that window, and it's okay for you to say no. Give them that power, right? Just like you would give your sellers, give the tenants the power to say no, because when you give them the control, they're not always going to fight back, right? When they feel like they have the control, if somebody requested it within 3 hours instead of 4 hours and they can accommodate it, they're going to say yes because they know they have the power to do that. So just make friends with them. Raekwon.
I had a situation where I showed a client a tenant occupied property, and the tenants were still there, like in the house. Mm-hmm. Like, is that something I should like be worried about, or just tell my clients to not say anything?
Yeah.
The tenants were just like, oh, we leave.
Right. So Raekwon said that he has shown tenant occupied properties where the property is still physically tenant occupied, like the tenants didn't leave for the showing. And that will happen more often than not because they don't have a vested interest. And when you are on the listing side, when you make friends with the tenants and you go over this with them, you can tell them, hey, you can stay until the showing gets here. And then if you just go outside and let them walk around, and then you can go back in. You don't have to actually physically leave, right? When we have sellers that don't want to leave or stay until someone shows up, right? Unless it's an extenuating circumstance, it actually makes buyers feel uncomfortable when the owner is there, because they think that there is something about them personally that's going to make the decision about whether or not they get their offer accepted, right? So with a tenant, the tenant has no skin in the game, right? The tenant doesn't get to make the decision one way or another. And if they just step outside so that the new prospective tenant can walk through with their agent and speak freely, that's better. Sellers should absolutely skedaddle before anybody could ever arrive at the property. And even as an agent, like, I feel uncomfortable. We are actively looking to buy a home. And a couple weeks ago, we had scheduled an appointment for 9:30 in the morning to get in. I wanted to be the first showing because that's who I am, right? And we pulled up to the property at 9:30, and I could tell that the owners were still in the house. And I was like, okay. I told my husband, I said, let's just drive around the block, right? So we drove, and of course he was driving too fast. I'm like, slow down, gotta give them time to get out of the house, right? So we come back up, we're still in the house. I'm like, ah. So we drive again. So like 10 minutes go by and they're still in the house. And I'm like, something's not right. So I called the agent, I didn't get an answer, and I was like, okay, I'm gonna go knock on the door. Because I didn't know if maybe they were just waiting until we got there before they left, right? But I didn't want to. I didn't want to knock on the door. I did. Now, selfishly, I'm like, hey, maybe if I talk to them, then I can make nice, and then they'll accept our offer if we want to make an offer, right? Like, I'm thinking that. But ultimately, I don't want to put them in that position, and I just don't want to be in that position, because I wanted to give them time to leave, right? But they didn't know about our showing. They didn't know. They thought their first showing was at 10. So we did get to see it. They were like, just give us a minute, like, no problem. And there was actually another showing scheduled for 9:45, and that agent was cranky. I locked the door. I didn't let him come in. I was like, give me a couple minutes. Like, for real. Yes, ma'am.
Tenant has the right not to allow showing during his release. Say no. After I go, you can show.
They do not have the right to decline showings. The tenant does not have the right to decline showings. It says in the lease that the landlord has the right to relist the property for sale and or rent at the end of the lease term. And this comes back to practicality, right? What does the lease say versus what can you actually get to happen, right? You can't go over and force your way into a house that someone is occupying. Regardless of what the lease says, your remedy is court and attorneys. So you don't want to do that. You want to make nice with them, right? Just like when I'm nicer to you guys, you do your paperwork nicer, right? If I'm cranky, then you guys are like, I don't want to do what she's asking, right? It's the same thing. All right, the landlord's assumption of risk is the same here as it was in the listing agreement. So remember, if there is a period of time, generally 2 weeks, it's generally 2 weeks that the property is vacant. That's when the homeowners insurance company gets all flaky and weird about the fact that you've abandoned your property. So if there's a period of time that you're going to be in between tenants, make sure your landlord knows to tell their homeowners insurance company. And when we get to the lease, there's also a place in there that says that if the tenant is going to be away for a long period of time, they have to let the landlord know, because the landlord has to let their insurance company know. Okay. And then we talk about appropriate professional advice for the landlord, right? They're going to ask about tax implications and consequences and things like that, and you are not a tax professional. And then the attorney's fees are the same here. Okay, questions on this listing agreement? Yes, ma'am.
If you have a walkthrough with your tenant, with your client, and you find anything in the—
Do you mind if I stop you for a minute and we talk about the walkthrough when we get to the lease?
Oh.
Okay, thanks. Okay. Yes, Misty.
How often do you find that the HOA has restrictions that a landlord doesn't care about? So very often, like, the landlord's like, oh, I don't care if this happens. And the HOA is like, no, this is a rule.
So,
You said pets and then like home businesses.
Yeah.
What else would be?
Grills. So Misty's asking about the difference between, you know, like when a landlord says, I don't care about this, but the HOA is like, that's a rule, you can't do it. So pets, home businesses, grills, trampolines. I could probably come up with some more things, but
quite often.
So I actually had it happen with, this was many years ago, and this is when I was new. So of course I learned things, and then you guys get to benefit from everything that I learned. I had a landlord who, no, I was the tenant's agent, and we didn't think about it. She had 2 dogs and rented a condo, and the association only allowed 1. And so we actually, the landlord didn't care, right? And the landlord did go to the association for an exception because they were little tiny dogs. And I think ultimately they gave a temporary exception for like 6 months so that she could find a place and it didn't financially hurt the landlord. But that's something that now I'm always going to think about is the number of pets, right? Because I learned from that, and I'm always going to talk about it in my classes because I want you guys to learn from my mistake. All right, presence of lead records. It's a much smaller disclosure because the tenant is not going to be doing any like risk assessment or anything. It's basically just asking if there is any information that the landlord has on lead. All right, boy, I have this packet all kinds of out of order. I apologize for that. However, if you want to bring this document to Advanced DocuSign class on the 4th Monday of this month, I will show you how that you can split the document and rearrange it so that it does make sense, because that's something that I teach in Advanced DocuSign. Just a little plug for another time that you can sit and listen to me yap for a little bit. Exclusive right to represent tenant. Almost exactly the same as your buyer agreement, okay? Almost exactly the same. Our duties are just a little different. We're finding property to lease instead of a property to buy. And that's pretty much it, right? Your purpose is to find a residential rental in Virginia. Your payments. So here, on page 2, like I said, most of what I see for tenants is not less than 25% of 1 month's rent. You can charge whatever you want, right? You could charge 50%, and if the landlord side is offering 25%, then you can charge your client the other 25%. It's up to you. So you would put 20, if you're charging the 25% of 1 month's rent, you would say 25% of 1 month's rent. Excuse me, that's what goes in that block. If you charge a flat fee, you put the flat fee. Relocation program. Sometimes, but not usually. Designated representation or dual representation. We remember what to put here. Fair housing laws, attorney's fees. Is the tenant licensed, active or inactive? A disclaimer that we are not an attorney, a tax advisor, a lender, an appraiser, a surveyor, a structural engineer, yada, yada, yada. We don't usually have to be psychiatrists. We're much more of an Uber in rentals on occasion. Service provider referrals, there's not generally a service provider referral that you're going to give in a rental. And that's it. For rentals, for the tenant side, you are going to have the tenant agency agreement and the cybersecurity notice. That's it for your compliance for the tenant folder. Okay. For the listing folder, you're going to have the listing agreement, cybersecurity notice, lead-based paint if it applies, and a tax record so that I can verify their name. Okay. And before we go any further, I'm going to stop sharing. I'm going to pull up a tax record before this computer in the back gets tired again. And show you a tax record. I use this tax record on occasion in my classes. Some of you guys might have seen it before. Make it a little bigger. Okay. So this property is property that my best friends bought a couple years ago. Ruined my life because they lived 2.5 minutes outside my back door, and then now it takes 5 minutes to walk to their house, and it completely ruined my life. My best friend's name, common, right? What everybody knows her by is on shell Lurs, okay? Somehow in this tax record, it actually reflects Lurs as her last name. Her husband's name is Jerry Lurs. Her legal name is actually Angelina Johanna Maria Dinkgrave. They are from the Netherlands, and she did not legally change her last name. So when Loudoun County was entering the information from the deed, they just left off her last name. They just used Jerry's last name. So I use this one as an example because there are a couple of ways that it could go wrong on this tax record, where if a buyer was coming in to make an offer, they would have it wrong because they would put Jerry C. Lurs and Angelina J.M. Lurs. And that's not how the deed is taken. That's not how title is. It's Jerry C. and Angelina J.M. Dinkgrave, okay? So it's important to let the buyers know what it should be. When you're talking to your sellers, it's important to verify this information with them. In my database, I don't have them listed as Jerry and Angelina, right? Who's Angelina? I've never called her that. Nobody's ever called her that. I have her as on shell. So just be aware when you're looking at these things that sometimes they're a little wonky when you're looking at them. They had a property that was a rental that they sold, and oh, it doesn't come up on there. I think it. I want to show you where it comes up that shows. Okay, so here, their previous home, it shows the tax record was entered as Jerry Lurs and Dinkgrave Angelina, right? So it imported it wrong even then. So just be aware that the tax record is not always correct. So if we go back to this one and we just are looking at the tax record to see where the information comes from that you guys are going to look for your documents. The book is 2016 and the page number is right up here, okay? The book is generally the year of the last transfer. Okay, so they bought this property in 2016, broke my heart. Okay, you can see from the record date, they went to closing on December 1st. That's the page number, deed book, LIBOR number. The LIBOR is the page if you see something that says LIBOR. Tax map is over on this side, tax map and tax ID number. So you would have the tax map / tax ID number. There's other information that you would get from here when you're doing your CMAs and things. When you scroll down to the bottom, this right here, Ashburn Farm, S9, BK1, L25, 2267-284, this is the legal description. Okay, so this is what would go on that property disclosure statement with their address. Now, as I'm reading this, what I can tell you is Ashburn Farm is the neighborhood. S9 means section 9. BK is block 1. And they are lot 25. So that's how you can decipher the code on the legal description. All right. So if you don't see it somewhere else up here to get the information, then you would scroll down and look at the legal description to get the information. Okay. Any questions? Does anybody on the call have a property recently or currently that's owned in a trust that you're dealing with that I can pull the tax record up on so that I can show what it looks like when it's owned in a trust? Is anybody working on one? Or an, yes.
I think my buyer, the one that my buyer has, I can't remember if it's a trust or an LLC. It might be an LLC.
Okay, but that would work. Either way, that would work. What's the address? What's the address?
73 Louisa Avenue. It's in Mineral.
Oh, bye. Perfect. Okay, perfect. That worked. All right, so here, what we see on this tax record is in the owner name, it says Whitlock Home Place LLC, and then there's a company owner line that says Whitlock Home Place LLC. If this was a trust, it would say maybe the trustee's name, and it would say TR, or maybe it wouldn't even say TR. It would just say something, just the owner's name, whoever the contact is that it's mailed to. And then there would be a company owner line that would say the trustee's name. It doesn't generally say the trust. It will say the trustee's name with TR, and it's in all caps. So that's a lot of the times how I figure out that there's a home that's owned in a trust, is I see those two things. Now, it's not always going to say TR. It'll say, or I'm sorry, it's not always going to have this company owner name, but up here in this owner line, it'll say TR. And so that's going to be my catch, that it's a trust. All right, but this is a different way that it could be listed, so then I know that we need additional information. All right, does anybody have another one? Or we don't have to look at another one. I just wanted to make sure that I showed you guys. Okay, now we will go back to the documents that we were reviewing. Here's rental application. So now that you have your tenants, signed up with you in the tenant agency agreement, there's going to be an application. In the MLS, you will follow the instructions of the listing agent on whether or not to use the NVAR application or some other application that they have. There are online application portals that some of the companies use, and they will all follow the information that's required in this NVAR application. So my suggestion to you is when you're working with a tenant and you have your tenant consultation appointment and you're getting the tenant agency agreement signed, go ahead and give them the rental application with it. Have them fill it out, leaving the property information blank, okay? But have them fill out the rest of the information for themselves, you know, their personal information, their address, their employer information, you know, et cetera, and gather the documents that are listed on page 2. That way they're ready to go when they have to fill out an application. If it's online, they at least have all the information handy, right? Their last 2 pay stubs, W-2s from last 2 years, or their 1040s and Schedule C if they're self-employed or have tip or bonus income. They need to have 2 years of employment history written down and occupancy, any additional income, debts, assets. They need to fill out these disclosures. This also right here, having them fill out the disclosures and send you a copy of this application up front is also important, because then you know if there's something that you need to know before you take them out, without asking them questions that you might be uncomfortable asking them. Like, how would you rate your credit? Have you ever filed for bankruptcy? Have you ever been evicted? Do you have any judgments, right? How awkward is that to sit across from someone you don't know and ask them questions, or someone you do know and ask them those questions, right? So by having everyone that you're going to work with as a tenant fill these out, you are treating everyone the same, and you're getting important answers to questions that you need in order to help them appropriately. If they answer yes to these questions, you can still help them. It could be a little harder, and you can still help them. And what I would do in this case, if they answer yes to these questions, is I would have them proactively write a letter of explanation that you can include with the applications that you submit, so that when the answers come back, the landlord has the information to review up front. Yes, Raekwon.
So a way of vetting like tenants or a client, like I'm a renters agent and the tenants come to me asking to rent, could I like make a, what is that, Google Forms thing that I could like have these questions on and send it to them before we go out to look for homes?
So I wouldn't put it on a Google Doc. I would just send them this document.
Okay.
And have them fill this out and give it back to you.
Gotcha. Okay.
And that way there's no question, because it's a Realtor Association provided form.
Gotcha.
Okay. So this is pretty self-explanatory on this document. All right, now I'm going to go back to the lease. So close your eyes so don't make you sick, because I'm going to zip right up to the top. Okay. All right, now we have the lease. So the lease is, actually, let me go back. On the application itself, there is a place on page 1 that asks for the application fee and the deposit. So the deposit is actually the first month's rent. Okay, it is not the security deposit. It is not any other type of deposit. It's the application fee plus the first month's rent. If we are on the listing side, it's payable to us, to KW United. That gets applied to the commission that's due to Keller Williams. So if you are only charging 75% of 1 month's rent, we still collect the full first month's rent and then distribute the commission accordingly. And then that overage, that 25%, would be issued back to the landlord. Okay, so the lease. The lease is fill in the blank. The lease is prepared by the listing agent, okay, not the buyer's agent. The listing agent comes to you and says, would you please create the lease? They're being lazy. The listing agent on behalf of the landlord is going to fill out the lease. So the lease is made on whatever date, effective date. It's really the date that you're preparing it. It's not the date that it starts, because that's down below. Between the landlord and the tenant. Okay, the landlord is not the property management company. The landlord is not the agent. The landlord is the owner that is on the deed. So if the home is owned in a trust, then that's what goes on that line. Okay, if it's owned by an LLC, the landlord is the LLC. And then the tenant's names. Listing company and leasing company, right? And then the leasing company, of course, if that's your side, then it would be marked as represents the tenant if you are representing the tenant. Premises is very self-explanatory. Address, subdivision, parking space, and mailbox number. It is okay to put a parking space number here. For the lease, if it's not conveying like on the deed, because the tenant needs to know where to park. Lease term. All right, the lease term is at whatever time, AM or PM, on whatever date. So this is negotiable. It used to say noon. It used to just automatically default to noon. But this can be decided by your landlord that they're going to have the property available at 8 AM, or they're not going to have it available till noon or 10 AM or whatever on the lease start date. And it's going to end at whatever time on the lease end date. So 9 PM, 5 PM, noon, whatever. Just think it through before with your landlord before filling in a random time. Most leases are going to end on the last day of the month. So you're going to have prorations if the lease doesn't start on the first day of the month. Okay, so let's say a lease starts today and they want a 12-month lease. You have two options. You can do 1 year that goes through 9/14/2022. Okay, so that ends in the middle of the month. Or you would go through 9/30 of 2022. So it would be 12 full months plus the 15 days in September. That's the prorate. Okay. Early termination of occupancy. This is important. Oh, sorry, I'll back up on the lease term. The landlord or tenant may deliver notice to either party that they wish to extend the lease or execute a new lease not less than 60 days prior to the end of the lease. Okay, there is no month-to-month holdover at the end of the lease. The lease expires and the tenant's got to go. Okay, so you got to figure it out at the end of the lease, what's going to happen. Either you're extending or moving out. Now, they could extend in writing month to month. That's okay. But there's not an automatic month-to-month holdover. Tenants shall not be released from liability if they try to terminate the lease early or vacate prior to the end of the lease. So let's say the tenant moves in and after 6 months, they want to buy a house. Well, there's no lease break option, right? Can the landlord and tenant agree to something? Yes, but there isn't an automatic formula for lease break in here. The rent, okay. This section is confusing for agents. The total rent for the initial lease term shall be blank, payable in monthly installments. Okay, so right here is whatever the total amount of money in however long the lease term is, it's going to go from the tenant's pocket towards the landlord's pocket. Okay, so if this is 12 months exactly, and the lease is $2,000 a month, it's going to be $24,000, right? That would be the 9/15 to 9/14 lease. It's exactly 12 months. It's $24,000. The first full month's rent for blank in the amount of $2,000, right, shall be paid prior to occupancy and is payable in certified funds, cashier's check, or money order. Okay. We always collect a full month's rent because we want to make sure that the tenant has the capacity to pay a full month's rent. If they move in on the 25th of a month, then they only had to pay the prorate, that's only 5 days worth of rent they'd have to come up with, right? We want to make sure that they are financially able to pay a full month's rent. So in this case, the first full month's rent for October in the amount of $2,000 would be paid prior to occupancy. That's what they pay with their application. Monthly installments of $2,000 are due in advance on the first day of each month, beginning on November 1st, without notification, demand, or deductions. Okay, so the following full month, they're just gonna have to start making their lease payment without anybody saying anything. They just have to start making their payment. Now let's say we're doing the move-in of 9/15 and the lease is going to expire on 9/30 of 2022. Okay, so it's a 12 months plus the prorate. Okay. The total rent for the initial lease term shall be $25,000. And you would normally figure out the daily rate, but we're just going to cut $2,000 in half to make it easy. Okay, so it's the $24,000 plus your prorate of $1,000 for the half of month of September. Okay, so it's $25,000. Payable in monthly installments. The first month's rent, still for October, in the amount of $2,000 will be paid prior to occupancy and is payable in certified funds, cashier's check, money order, or the wire transfer. Monthly installments of $2,000 are paid in advance on the first day of each. So far, right? If the lease begins on a day other than the first day of the month, the rent shall be prorated with $1,000 due on October 1st for the period of September 15th through September 30th. All right, so essentially what we're doing is we're switching September and October's rent payments. We're just flipping them so that the full month's rent is paid up front and then the prorated rent is paid on October 1st. Who did I confuse? All right, that's good. I'm glad I didn't confuse anybody.
Shannon, is it okay if they go ahead and pay everything prior to occupancy?
Of course.
They're just given the deadline. Okay.
Mm-hmm. They can, absolutely. So the landlord can accept, it says right here, they can accept prepaid rent to be held and processed in accordance with provisions in the VRLTA. So what does this mean? This actually means that our landlords should have a separate rent escrow account to hold the money that they collect prior to when it's due, right? They should have a separate account for the security deposit and pet deposits to be held in, and then another account that's rent escrow. That means any rent that they receive prior to when it's due goes into that account. All right, late payments, return checks. For rent payments received by the landlord after the 5th of the month, it lays out very clearly what the landlord's allowed to charge. So rent's due on the 1st, and they have a grace period to the 5th. The landlord can charge the tenant the lesser of 10% of the total monthly rent, or 10% of the remaining balance due and owed by the tenant, by the tenant. For any return check or insufficient funds or failed electronic funds transfer, the landlord can also charge a fee in addition to that late fee. They can charge the amount charged by the bank for the dishonored payment, an administrative fee of $50, and interest. Late payments and dishonored payments constitute default under the lease. Okay. Ooh. Normally we hear fire trucks, but now we're hearing car alarms today. All right, failure to pay. Tenants' failure to pay rent will require that the landlord serve notice to the tenant that they want to terminate the lease, and the tenant has to have a redemption period in order to bring their account current before the landlord can proceed with any like eviction processes. Now this says that if the tenant doesn't pay within 5 days after they've been given the default notice, that's a 5-day notice to pay or quit. And it's actually not 5 days anymore. It is 14, I believe, either 10 or 14. I think it's 14 days. It's not a 5-day pay or quit anymore. I think it's a 14-day pay or quit. And that's because of all of the eviction moratoriums and tenants that were out of work and everything that was done to protect the tenants. They extended that period of time that the tenant has in order to redeem the property before any unlawful detainer cases can be filed with the courts. Management. Okay, so if there's a property manager, this is where the information goes for the property management company. If the premises are not professionally managed, then the address for the landlord and their contact information goes in that next section so that the tenant knows how to reach them. And it just clarifies that the listing company is acting only as a rental agent and doesn't have any responsibility for property management or escrow funds other than that first month's rent that we collect. And the computer just did a thing. Appointment of resident agent by non-resident landlord. So the VRLTA requires that if a landlord lives out of state, that they have a resident of Virginia be designated in the lease as a contact person. This is not a property manager. This does not mean this is the contact person. That is who the landlord is saying that the tenant has to reach out to. It's just an additional contact person for the tenant to reach in the event that the landlord is unreachable. So this is really meant for cases when like a landlord is stationed overseas and they don't want to hire a management company and they think they can do it themselves, and they're not reachable because they're like in Japan. And so it's 12-hour difference, right? And there's an emergency in the, middle of our day, which is the middle of their night. Okay. So they can. They can. They just don't have to. And in a lot of cases, if they have a property management company, then the property manager is the resident agent who's designated by the landlord. All right, truthfulness and representations in the rental application. Okay, so this is important because let's say the landlord entered into this lease with the tenant based on information that was provided on the application, and then it was found out that the information on the rental application was false. So if there's material facts that are in the application that are found to be untrue or inaccurate, the landlord has the right to terminate the lease. And they also have the right to recover damages and other equitable rights under the law because they were misled. All right, uses. It lays out what the uses are for the tenant, that it's going to be used as a single family residence only for the persons listed on the application or those children born, adopted, or placed under their legal care thereafter. Okay, so there's no subletting allowed or assignment of the lease without prior written consent of the landlord. Visits by guests are allowed but cannot exceed 2 weeks during any consecutive 12-month period without written consent of the landlord. It goes on to say that the tenant can't do illegal things in the property. Obviously, even if the landlord said they could do illegal things, obviously the law supersedes that. The landlord can give the tenant notice to terminate the lease within 72 hours if they find out that there are activities being conducted that constitute criminal activity or are a threat to public health and safety. There's a section here for pets that says whether or not the tenant or the tenant's guests can have pets, and there's an additional pet addendum that I will show you if they're allowed to keep pets. And then smoking. Can the tenant smoke? And this also is inclusive of electronic cigarettes or vaping. And the next section talks about that HOA situation, right? Is it in an HOA, and will they be provided with the rules and regulations? Have they been or will they be? Because they are required to comply with all of the rules. Vehicle parking, it talks about vehicle parking. Utilities, tenant must make any required deposits and pay for the following utility services. So any services that are included in the rent wouldn't be marked here. If it's included, then it's just included. So if they have to pay for additional services, then that would be marked here. And if there is a certain utility that they have to pay for from a specific provider, then that would be listed here. So for example, if there's propane, right, in the property and it's not included in the rent, that would be marked here that the tenant agrees to purchase, the propane from Holtzman Propane, right? They can't order it from somewhere else. Landlord maintenance, except as otherwise noted, the landlord will maintain the premises in compliance with the Uniform Statewide Building Code and VRLTA, and is responsible for all repairs not due to the fault or neglect of the tenant. Okay, so if the tenant knows there's a leak somewhere, and doesn't ever tell the landlord. And then all of a sudden it's like, oh, there's mold, right? Well, the tenant really needs to fix it, right? Because the tenant knew there was a leak and never told anybody. Okay, fixtures and appliances. It drives me nuts when I see on this line for appliances that it's either blank or it says all listed in the MLS or all provided or something vague. They need to be listed out. Washer, dryer, refrigerator, ice maker, disposer, stove, or cooktop, 2-well ovens, whatever. They need to be listed out. Then as is appliances, of course, would be like that second refrigerator or anything that is being left in the property, maybe like a microwave, a countertop microwave could be another thing that might just be as is. Smoke and carbon monoxide alarms. This is something that a lot of our sellers and landlords don't know, that the landlord has to certify that the tenant that smoke alarms have been installed in accordance with the law. The tenant should be checking the smoke detectors, but the landlord has to actually check these before the tenant moves in, and sellers have to check and make sure that all of the smoke detectors before they sell are up to current regulations. It's not a walkthrough item. It's a pre-printed item, just so you guys know. Security deposit. Okay, security deposit. Prior to the beginning of the lease, tenant shall deposit blank security deposit to be held by who? Okay. Usually we see 1 month's rent. The max we can collect is 2 months rent. The maximum that the landlord can charge is 2 months rent. And it's held by the landlord or the property management company. Where it says to be held by should never, ever, 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 ever say Keller Williams or KW United. It should only say the property management company or the landlord. We don't hold security deposits. So it is something that I look for when I'm scanning through the leases. I'm looking to make sure that it doesn't say Keller Williams. And if there's a property management company that's managing it, I do notice it will catch my eye if it says that the landlord's holding it, because normally the property management company holds it if there's a management company. So I might send a note that says, hey, double check who's holding that, because you want to make sure that the right person is noted. Mm-hmm. With the security deposit, it is not to be used towards rent during the lease term. All right, the security deposit is for repairs and outstanding balances for the end of the lease. The landlord has to give written documentation itemized to the tenant within 45 days of vacating the property of what they're charging them for if they're not returning the full deposit. And it lays out in this section what the requirements are on that. It also says the tenant needs to provide a forwarding address. Obviously, they can't receive that notice of what's being held from the security deposit if they don't provide that forwarding address. The tenant also has the right to be present for the final walkthrough if the tenant would like to be. The move-in inspection is within 5 days of the beginning of the lease term. The landlord shall submit a written report to the tenant itemizing the condition of the property. And the tenant then gets to submit to the landlord the condition of the property as well, so that there's a meeting of the minds on what the condition is, or at least documentation on what everyone thinks the condition of the property is, right? So the landlord is supposed to document everything that they saw when they walked through, and the tenant is supposed to say everything that they saw when they walked through. And that all has to be done within 5 days of the beginning of the lease term. So it's super important that if you have a tenant who's taking possession, like on the 1st, and they're not moving in until the 15th, that you get in writing an extension of that move-in inspection, because just walking through, you're not going to notice things. You have to be physically moved in order to start noticing things in a lot of cases. Tenant obligation. So the tenant needs to keep the landlord informed of their contact information. They have to maintain the premises in a clean and sanitary condition. They have to keep all of the appliances and equipment operating in a safe and reasonable manner. If something breaks, they need to report it to the landlord immediately. They need to replace light bulbs and fuses and furnace air filters every 2 months as needed. Make sure all drains are cleared and toilets are and showers and tubs are caulked. Maintain the premises to avoid accumulation of moisture and mold growth. The lawn and exterior shrubs are to be cut, watered, and maintained, right? Keeping gutters and drains free of leaves and other debris. Paying costs of any unnecessary service call for the landlord that's a result of the tenant not keeping appointments for service people. You would think that that would be a no-brainer, but that had to be added to the lease. Any alterations to the property have to be in writing from the landlord. So if the tenant wants to paint, they've got to get written permission from the landlord to do that. Providing notification if the tenant intends to be absent from the premises for more than 14 days. Not creating or permitting any lien to be placed upon the premises. Okay, and the tenant will comply with all obligations imposed by Virginia and VRLTA law. So the holdover tenant, it states that what happens if the tenant doesn't move out, right? Because there isn't an automatic month-to-month at the end of the lease. This says that the tenant will become a holdover tenant at the end of the lease if they don't move out, right? And the rent is equal to 100% of the per diem for each day and the costs payable to a new tenant for moving, storage, meals, lodging, mileage, damage, etc. So they're gonna have to pay a lot if they stay, especially if it's been re-rented to someone else. Liquidated damages can go up to 150% of the per diem. So it's not cheap to be a holdover tenant. And there are certain additional things besides like remodeling and painting that require the landlord's consent. You know, it talks about putting nails into the wall. Generally, landlords, you know, don't mind a few nails in the wall, but I would always double check. If you're a tenant and if you're a landlord agent, I would talk to the landlord first and say, what are you going to be reasonable about as far as hanging pictures, these types of things. Tenants should always be cognizant of, you know, like hanging wall mounts for TVs, and tenants cannot rekey the property. They can't change the locks without providing a key to the landlord. The landlord owns the home. anything that's extra heavy, like a waterbed or an aquarium that's over 20 gallons, has to have permission from the landlord as well. And the renter's insurance has to be in place at the beginning of the lease term. I see a lot of times in like the other terms at the end of the lease, people will write in no smoking and renter's insurance to be provided, like all of these things that are already provided for in the lease because they're not reading it. And then of course, all of the legal fees and et cetera that are standard in everything that we do. If you're at fault, you're paying your legal fees and everybody else's legal fees. Access to premises. Okay, so access to premises, the landlord and their representatives, upon reasonable notification to the tenant, can enter the property to do inspections, make necessary or agreed upon repairs, supply necessary or agreed upon services, and the landlord should arrange for contracted workers to coordinate with the tenants when at all possible. The landlord or designated representative can show the premises to prospective buyers 90 days prior to the end of the lease term and 60 days prior for tenants. The only lease break clauses that are in here that are pre-printed, so it's not that there are none, but there's only a couple, and there's very specific circumstances. The transfer of the landlord, if this section 27 box is checked, it says that the landlord lives out of the area, and if they are transferred back to this area with the employer that they were employed with at the time they entered into this lease, they have to give 2 months notice to the tenant that the tenant will have to vacate because the landlord's going to come back and occupy the property as their primary residence. Okay, but it has to be that they're transferred back with the employer that they were working with when the lease started. Same thing goes for transfer of tenant. If the transfer of the tenant occurs to a place more than 50 miles away with the employer that was on their application, then there is a lease break opportunity where if it's in the first 6 months of the lease, then they have to pay a lease break fee of 1 month's rent. And if it's after the first 6 months, then it's half a month of the rent. And military service members, of course, are exempt, right, from any penalties for breaking a lease because they get orders and they get shipped out, and that's 35 miles, or TDY for more than 3 months. Okay. And then
Shannon, I got a question.
Yes. Sure.
If a tenant has signed for 1 year lease and then it expires after 1 year, and they decide to stay for another 8 to 10 months, do they need a new lease agreement? Legally, is it required?
They would either do a new lease or they would do an addendum to the lease extending the term.
Or if the landlord just agrees, yeah, you go ahead and stay for, longer time. Is that okay? Or do we still need a legal document that
it has to be in writing?
It has to be in writing?
It would need to be in writing, yes.
Okay, just a text message or an email, no. Would that be okay?
An addendum to the lease is what would be enforceable, yeah.
Okay, thank you.
Something that everybody signs.
Okay, thanks.
Okay, so if the landlord can't deliver possession of the property at the lease start date, so let's say the previous tenant moved out and the property is just a disaster and they have to do repairs before the new tenant can move in, the landlord has to provide the tenant with an alternate place to live I mean, usually it's a hotel. And if they can't give them possession within 15 days after the lease start date, then the lease can be terminated by the landlord or the tenant. Bankruptcy, this is subject to the requirements of federal law for bankruptcy. And condemnation, we don't really hear that very much, but in the event that the premises is taken in whole or part by the government, the lease shall terminate. But again, there's not really much of that would happen in our area. Now, what happens if there is a death of a tenant or a landlord? So if the tenant if there's only one tenant and the tenant dies, then the lease is automatically terminated, okay? Because the tenant, there's no way for the tenant to continue paying. If there's the death of one tenant, but not all, the lease can be terminated by any party, giving 60 days written notice, okay? If the landlord dies, the lease can be terminated by the remaining landlord or the estate by giving written notice of at least 2 months. So it's only if the sole tenant dies is the lease completely gone. The other two options, it means that there is, it can still be enforced. It can still be honored, right? If the landlord passes away, the estate can continue to honor the lease. So it doesn't have to be terminated. And it also says in here that the death of the landlord, it has to be exercised within 1 month after the landlord's death. And the same if the tenant passes away. It can't be like 60 days later and be like, oh, now I want out because now I found a house I want to buy. Okay. Fire and casualty damage. So the tenant's responsible, right, to have insurance that covers on the inside, and the landlord is covering the entire property. Sale to tenant, parties are notified that there may be a commission due under a separate brokerage agreement if the tenant should purchase the premises. All right, move out inspection. The tenant has the right to be present at the inspection, right? It must take place within 72 hours of the tenant's departure. So what does the tenant have to do before they leave? They need to have the carpets cleaned and provide receipts. Gutters and chimney must be cleaned professionally and provide receipts. This is something that I do see struck out regularly in the lease, that the landlord doesn't require gutters and chimneys to be cleaned professionally, but carpets absolutely. Have premises professionally treated for fleas and ticks if animals have been present, and provide a receipt. Eliminate all household pests and vermin, so pest control if necessary. Install clean air filters, and you're gonna have all the light bulbs replaced, return all keys and garage door openers, and make sure that everything is thoroughly cleaned and grass is cut and trash is removed. Okay, so the tenant really has to leave the property clean. That's different from a buyer coming into a property, because the seller doesn't have to clean the property, right? Light bulbs have to be put in those kind of things, but the home only has to be left free and clear of trash and debris. It doesn't actually have to be cleaned. All right, notices. How are notices being sent? By US mail, by hand delivery, by email? I would say email is probably best, so check electronic delivery. Lead-based paint. Was it built before 1978? If so, you've got that disclosure attached. Statement of tenant rights and responsibilities. I would say I return 75% of the leases that are submitted to me for review because they're missing statement of tenant rights and responsibilities. It must be attached to the lease. It is provided by the landlord side to the tenant. This is not something that goes with the tenant agency agreement or that we provide the tenant. This is from the landlord side to the tenant with the lease. So here in section 42, it talks about what's attached. Is there an assistance animal addendum, pet addendum, EPA booklet, tenant rights document, lead-based paint. Diplomats, it's just a disclosure in here to whether or not the tenant is subject or entitled to diplomatic immunity. Essentially what that means is that the lease may not be enforceable if the tenant is entitled to diplomatic immunity. And are we a licensed real estate party, yes or no? So those are basically the big ones here, okay? Brokerage information is important, just like on your listing agreement. The notice for the lease is something that is sent after the lease is entered into, right? After it's ratified. This would be something that is sent from one party to another. It's just information, right? It's not something that buyers or that landlords and tenants have to agree to. It's just one side notifying the other. Notices are not used for anything other than like an intention to vacate, really, right? Like we don't use those in leases very often. Addendums we do use because that would be an agreement that buyer and seller or landlord and tenant are agreeing to something. So in the case of an extension of a lease term, this is what would be used. Landlord and tenant agree to extend the lease to whatever date, right? You put whatever it is they're agreeing to. If they agree that the grandmother can come stay at the property for the summer, right? It's more than 2 weeks. You would do it on an addendum. So that's what you would use the addendum for. This document is the Virginia Statement of Rights and Responsibilities. This is something that I suggest you guys read because this is the tenant's rights and responsibilities. So this is what it's telling you certain things that we talked about already. Like security deposits. The landlord may require a security deposit of up to 2 months rent, right? It's little things that you might want a reminder of. Eviction process, there's links on eviction processes, how to redeem the property if your tenant has failed to pay rent and then they now have brought it current. Late fees, it's restating some things that are in the lease already, stating that the landlord must give 24-hour notice of any maintenance, normal maintenance, fair housing, COVID relief information, okay? And landlord agent, and tenants have to sign this. Tenant agent does not sign it. And then the last document in here, I think, is that pet addendum. So if there is going to be a pet, the pet addendum goes with the lease, and it basically lists out what the breed of the pet is, the color, the weight, pet's name. If there's an additional security deposit, and then the tenant's responsibilities for maintaining the property when it comes to the pet, liability insurance. There's additional insurance with your renter's insurance that you can get for the pet. And then the landlord and tenant sign this, okay? And that is it. All right, we're done with rentals. And there's a whole rental class that we can do that talks about other things like service animals versus pets and those types of things. We're not going to get into that today. That's too much. So what questions do you guys have about today's material? Alyssa.
So I have a rental client who asked to do a 10-month lease. How would you respond?
I would add, okay, so Alyssa's client asked to do a 10-month lease instead of a 12-month lease. So present it to whichever property they want to see and ask if the landlord would be open to a 10-month lease. A lot of times you could get a shorter than 12-month lease if you offer more money. So basically, if you're looking in the MLS and you see minimum 12 months at $2,000, well, maybe they'll take a 10-month lease at $2,100. So offer more money and you could get a shorter lease term.
I'd also say too, if you're trying to rent something during like kind of an off season, so not during the like spring, summer time, you can also mention to the landlord by doing a shorter lease, it might get you closer to the peak kind of rental season. So it might be easier or faster for you to rent next time. That's worked for me before.
Awesome.
Shannon, if I'm the listing agent for the leasing, which agency should I use for the applications? Do we have a recommendation? You know, when
yes, we use PPM, our in-house property management company.
Okay.
They will process.
And the application fee is the only thing that we will pay, right? The tenants will pay.
The tenants will pay, each tenant pays $50. So it's $50 per person. And then they pay the first full month's rent with the application to Keller Williams.
Okay. And the owner doesn't have to pay anything, right?
So that it's offset by the tenant's first month's rent, right?
Okay. Okay. Thanks.
So they are technically paying something, right? They're not getting the first month's rent. Okay, Mary.
The landlord cannot pay more than 2 months.
The landlord can't charge more than 2 months security deposit.
They can pay more than 2 months rent in advance.
Sure, the tenant can pay more than 2 months in advance. Yep, it has to go into a separate escrow account. Yes. Other questions?
Shannon, regarding the maintenance part of the contract, it states that the landlord should be responsible for repairs not due to the fault or negligence of the tenant. But I know it's pretty common in our area to see that there is some sort of deductible the tenant pays. Usually it looks like $50 to $150 maybe dollars if there's repairs needed. Is that only in the instance where it's not due to the fault of the tenant, or is it still okay for the landlord to charge a repair deductible if it's something that can't be directly attributed to the tenant's use?
It's okay for the landlord to still charge that if the tenant agrees to it. And usually those are, based on use, right? So the $50 or $75 for the home warranty deductible is, it is okay for the landlord to charge that.
And that should just be written into the other terms per the contract.
That is where it goes, right? Or on an addendum.
Okay, thank you.
Sure. Other questions? Nothing? Okay, so Monday, 9 a.m., we will be going over the documents for the contract, and it is day 4 in the link that I sent out. So it's called offer documents. So it's everything that you could use when presenting an offer. And then Wednesday will be our post-ratification documents, the most commonly used documents after a contract is ratified. So we may need a little more than just the 3 hours on Monday. So maybe just block to 12:30 just in case, because there likely will be more questions on Monday, but I will try to only keep it to the 3 hours because I know it's a lot of material. Also remember Friday, ask the broker at 11. So if you haven't asked me enough questions already, come at 11 on Friday and we'll have asked the broker. All right, thank you all very much. Enjoy the rest of your day.
Okay, bye.
Thank you.